Warm welcome viewers, you're watching To The Point. I'm Preeti Chaudhary. Let's get you the latest in the Bilkis Bano case. Well, the Supreme Court today sent a notice to the Gujarat government and sought its response on a plea challenging the release of 11 men convicted for the gang rape of Bilkis Bano during the 2002 Gujarat riots. The bench was headed by Chief Justice NV Ramana, who's on his way out, retiring soon, asking the petitioners to implead those who have been granted remission as parties in the matter as well. Now, the bench also posted the matter for hearing after 2 weeks. Let's get you two very important observations that were made today by the highest court and the bench. At the very beginning of the hearing, Chief Justice Ramana sought to clarify that this May 2022 order only asked for remission to be considered where applicable. He said, and I quote, "I read somewhere the court has granted permission for remission." No, the Supreme Court never granted remission. We only asked the Gujarat government to consider it. They could have rejected it as well. We have to see whether there was an application of mind or not. This court did not order for their release, but only asked the state to consider remission as per the policy. Another noteworthy observation that was made today in the hearing was a question posed by Justice Ajay Rastogi, who was part of the bench. He said, and I quote, "Merely because the act was horrific, is that sufficient to say remission is wrong?" While the pleas will be heard 2 weeks from now, what remains to be seen is, will Bilkis's defense move for judicial review, and importantly, it will need a copy of the remission order, which strangely has not been given to Bilkis nor the convicts' lawyers. Joining me now will be both the lawyers, Bilkis Bano's lawyer and the lawyer of the convicts. All right, joining me right now is Ms. Shobha Gupta, Gujarat riot and gang rape survivor, Bilkis Bano's lawyer and an advocate. And with her is also Rishi Malhotra, lawyer who appeared for one of the convicts in Supreme Court. So he's defending the convicts in the Bilkis Bano case in Supreme Court. And we also have Shobha Gupta, Bilkis Bano's lawyer. Ms. Gupta, the pleas that were entertained today, a notice has been sent to the Gujarat government. But when you just look at the pleas in general, when it comes down to the, just the pleas in particular, many suggest that they are weak, that, 2 weeks from now they won't be able to stand in court.
Whether the petitions would finally stand to get any relief or not, on what count they would not be able to get, I do not know. That is something time would tell. But the fact that people have come, challenged that remission order, conveyed it loudly to Bilkis that you are not alone, we are there and we can take up the cause. I refuse to accept that argument of no locus. Each one of has the locus in this particular case. That technical argument of criminal case, strangers and all that, I'm not really getting into it. But as on date, I'm very happy that Supreme Court has taken cognizance, issued notice. The counsel for the convicts raised the preliminary objections. Court for today ignored that. What happens in subsequent hearings is something we have to see then. But today, as far as today is concerned, it's a good move, good progress, good development in the matter.
I'm going to come back to you, Ms. Gupta, on what would be Bilkis Bano's stand from here on, but I want to cut across to Rishi Malhotra. Rishi Malhotra, a lot of objections that was raised from the convicts' part were not entertained in court today, but yes, the 11 convicts have been, now the plea will have to include the 11 convicts as well.
You see, there were threefold preliminary objections which we sought to raise. One was that there was no locus standi of a political outfit to challenge any remission order, because the criminal law jurisprudence categorically states that there are no third party or strangers which are allowed to perpetuate a criminal litigation. Of course, had the victim or the complainant or the state or the center, if they would have come, certainly the things could have been different.
But with PILs,
but certainly
Mr.
a stranger
Malhotra,
to a litigation is not
we'll go one by
permitted.
one. Mr. Malhotra, we'll go one by one, if you don't mind. Number one, the locus standi that has been challenged. If somebody is aggrieved, then they are well within their rights to lodge a PIL. What's wrong with that?
That somebody has to be a person related to a crime He may be a victim, he may be a complainant. But it can't be a roadsider or a stranger who just walks in the court and says that, no, I am aggrieved by a High Court order or I am aggrieved by an X order. I should be permitted to challenge in Supreme Court. I'm sorry, that's not the law in Supreme Court since 1992. A similar circumstances, Simranjit Singh Maan case was dealt by Supreme Court, where an Akali Dal MLA filed a petition in Supreme Court under Article 32, challenging the conviction of the murderers of General J.N. Vaidya. And the Supreme Court knocked that petition only on the ground of locus standi. Since 92 till 2013, when Subramanian Swamy filed a public interest litigation against that Nirbhaya juvenile case, the Supreme Court reiterated the law and again knocked out that petition on the ground of locus standi. So it's nothing new.
Okay.
And I would say with greatest of respect that if the Supreme Court interferes and entertains this writ petition, this will be acting contrary to a settled law and settled principle.
Well, they've decided to do so. I'll come back to point number 2. Give me a minute. I'm coming right back to point number 2. Shobha Gupta, the locus standi, doesn't exist in this particular case, is what the convict lawyer is saying.
Well, see, Preeti ji, as far as this argument is concerned, legal argument we will deal in court. Whether we will not, I need not to deal with this argument at all. But this legal argument, I'm sure the petitioners who have filed it would deal with in their court. Me as lawyer for Bilkis, as a citizen of this country, a woman, a lawyer otherwise. For all those reasons, I'm more than happy that society, somebody from society, a representative of society, I'm not considering them a political party. I have seen the petitions. These are individuals who have come. So I can be associated to a profession, I can be associated to any other, whatever occupation I am in. But these are individuals and nowhere they are claiming their position as a petitioner because of belonging to a political party. I have seen myself both the petition.
Right, okay.
Individuals have come as a society.
I'm sorry, please have your facts correct. One is filed by a CJI member and other is by Trinamool Congress.
No, the Trinamool Congress, okay. Mahua Moitra has made it very clear that she's approached the courts in the capacity of Mahua Moitra, not Mahua Moitra MP.
But just let me complete.
Yes, go ahead, ma'am.
So this is, I have read the petition carefully. They have not, it is their duty to disclose all their credentials because that is the requirement of the guidelines for a PIL to be filed. If I file a petition, say I am a lawyer by profession, but I am raising this public interest litigation, public interest cause, or if Rishi goes for a public cause to be raised by a PIL, does that mean a lawyer has come and a lawyer wants to do this and he had been a lawyer for so and so? All this doesn't come. We are citizen first. They have gone as a citizen of this country, and as I have been saying, this is a collective pain caused by this remission order.
Right. This
is a national shame brought. We are pained collectively. Any of us could have gone. Law keep improving. We keep progressing when it comes to interpretation of these technical aspects.
Rishi Malhotra, what was
this matter also?
Yes, Rishi Malhotra, what was the point that you were raising on the second count?
Yeah. My second point of preliminary objection was, and that is very quite strange, I have never seen across my 25-30 years of legal experience, that a petition has been filed in Supreme Court alleging challenging of a remission order. And that remission order is not in court's file, and yet allegations are made that the remission order is bereft of this thing and bereft of that thing. And this is quite shocking actually, that they even don't know what has the reason transpired, and yet they are challenging a remission order without that order being placed on file to judges to see. And please don't forget, there may be 50 grounds in a writ petition. What is crucial in the court is what has been argued and what has been conceded. Mr. Kapil Sibal on 2 occasions, let me make this fact very clear. Mr. Kapil Sibal, who was representing the petitioner today, on 2 occasions made this thing very clear. Namely, first, that he is not challenging the judgment of Supreme Court of May 2022. Now what does that mean? It means that the Supreme Court ordering that the cases to be considered as per 92 policy remains untouched. Number 2, what today Mr. Kapil Sibal mentioned is that what all he wants is, and please mark my words, what all he wants is that whether there was any application of mind, that's all. Now, if the state of Gujarat as well as the central government produces the record and the counter affidavit and the judges are satisfied, yes, there was indeed application of mind, I am afraid these petitions have any legs to stand on.
But Rishi Malhotra, don't you find it a little odd that the fact that the remission copy that Bilkis's lawyer, Ms. Gupta, has actually, Bilkis has filed an RTI through her to get that remission order copy is not even with you, sir? How is it that the remission order copy is missing? Where is the remission order copy?
No, it must be lying with the state. That's my second point. That without, it was what you call a premature and what you call a speculative writ petition in Supreme Court, that they don't know what is the reason behind the remission order, and yet they just jump in the Supreme Court and mention it before the Supreme Court
Shobha Gupta, you want to come
and have this order got notice issued. Well, this is something.
This is something which perplexes, I believe, Shobha Gupta also. Yes, Ms. Gupta, go ahead.
So my friend Rishi is saying that in his 25 or 30 years of law practice, he has never come across petition like this. He must be forgetting in good old days, we have seen oral petitions, oral impugn order being entertained by court and orders passed when it comes to protection of human rights. Supreme Court is always proactive, and we have number of instances where oral orders, oral petitions and order passed. That is one. I myself have been in processes when we rush to court and 10:30 mention it and court would say we are protecting you. Now file the petition also. We have seen so many things. Now when it comes to technicalities, and my friend says I have never seen it. Believe you me, I have also not seen a 32 criminal petition, 32 petition filed in Supreme Court, not mentioning in the prayer clause that I am challenging this order. You have gone to High Court, your remission application dismissed. There is not even a whisper in the entire petition, have you gone to the state or not ever? And if you have not gone to state ever, how come you come to Supreme Court and say, I have not been granted? If it is not denied, how would you come here? A 32 petition, 9 judges bench judgment, Naresh Mirajkar is clear, against a judicial order, no 32 petition lies. In my career, we have seen enough number of judgments, 9 judges bench judgment, Rupa Ashok Hura 5 and 7 judges bench judgment, which clearly says no 32 petition can lie against a judicial order. Now it comes to what has not been placed. They are not defending those petitions. They have said, I have gone through the petition and the petition says that nobody has the remission order. So how long everybody have to wait, like Bilkis is waiting for these orders to come to hand to? 2, the petition my friend filed contained no order of, no judgment of trial court, no judgment of High Court, Supreme Court dismissal, nothing, no FIR, no charge sheet, not even a whisper of Bilkis' name in his entire petition. Not even a 2002 year does not exist in his petition. So my friend, when we are talking about what kind of petitions to be filed, we have enough to deal with.
Okay, yeah, Mr. Malhotra wants to come in for a rebuttal. Go ahead, Mr. Rishi Malhotra.
Yeah, I want to respond to this, my second objection. Have you seen the prayer in the writ petition? Now, this is very strange. The first prayer in the writ petition was that please direct the government to produce on record the copy of the order of remission. And immediately the second prayer was that the moment the order is placed, please kindly set it aside. So therefore, is it not a speculative writ petition that they assume and presume that the order must be bad in law, and therefore the order should be set aside? This is quite surprising for me to understand that on a speculative PIL by a third party, therefore Mr. Kapil Sibal just made this statement in the court today, in the open court, that what he needs to see only is, and what is beseeching the Supreme Court was there any application of mind?
Okay.
Because minded Justice Rastogi made it very clear in the court today during the course of argument that remissions are granted day in, day out. We just need to see was there any application of mind by the concerned authorities in grant of remission.
All right.
So I really fail to understand, without producing the remission order, the arguments are made against that remission order.
Well, you know, that perplexes
all. Now my third objection was, which was immediately allowed, was there was another prayer in the writ petition, that is prayer number 3 or 4, that my remission order should be set aside and we should be taken back into custody. Now, I think Shobha will also not disagree with this thing, that principle of natural justice demand that if you are alleging action against anybody, if you are praying an action against anybody,
right,
that party ought to be heard in any court of law.
But that was
you
included.
Can't be condemned.
Right.
You can't be condemned unheard, and then an order is passed.
All right, that was
so.
Okay.
Therefore, on that preliminary objection, the Chief Justice.
That was included, Mr. Malhotra.
On
but
that
I want to. Yes.
objection, the Chief Justice immediately allowed.
Yes. Yes, sir, that was included. Ms. Shobha Gupta, you wanted to come in for a rebuttal. Go ahead.
So, my friend said Shobha would agree, I would not agree. For the reason, we again have judgments. What is being challenged, be it the PIL or be it now Bilkis, assume Rishi, Bilkis has to come tomorrow. Right? You would not be objecting, locus? What about, even, we don't have the copies of the orders now.
May not.
Right? So, and I come tomorrow and say, sorry, I tried, I'm not getting it, but I still have to challenge these orders, and let these orders come on record and then deal with it. You have, if you wanted to mention prayers, I wish you would not added words into it. There was nothing of the sort in the prayers, Rishi, which says, the moment you get the order, then immediately set them aside. And there's no such language used in the order prayers. To my recollection, subject to correction certainly, I have not heard Mr. Sibbat today saying that we are not challenging 13.5. It was not even discussed too. Precisely everybody's challenge today is on the remission order. That's the major
Right.
fact. One may prefer to challenge 13.5 order of Justice Rastogi and Justice Vikram. That is something apart. An observation came from Justice Rastogi and added, caveated by Justice Vikram Nath, is that we had only directed for application to be looked into. We never asked for remission to be granted. Now we have to see the order to see what prevail over to the
Right.
competent authorities to pass an order of remission, which we would be able to do only when we have
Right.
the
You know,
advantage
I'm
of
running
having the
out of
order, which is
time.
all fair enough.
Right.
But
Make
to
your point.
say that accused had to be party, I would not be agreeing to this, according to me, and I can actually cite judgments
Right.
also.
I know.
You would always see, Rishi, you must be aware of so many service law judgments,
Okay.
otherwise also, if this is an
So-
order which
Okay, you know, I'm
You
gonna-
also must be
Just
aware
hold
that a
on, just
remedy
hold-
to challenge a
just hold
Supreme
on,
Court
just
order is a
hold on,
review,
Rishi,
not a writ petition.
Okay, I need to close. I need to
Just
close this edition of news, but I want to, this debate as well. But Ms. Gupta, I want to ask you one quick question, ma'am, before I let you go. The pleas will be heard now in 2 weeks' time. Is Bilkis going to move judicial review, or is she going to take any legal action before that?
See, I have now gone through the petitions yesterday evening or today morning. Yeah, yesterday evening. I have realized there are so many issues which are yet to be brought in. The PIL petitioners always have certain limitations, and unfortunately these petitions also suffer. Like they have not been able to raise
Right.
all the issues which we want to. So maybe if not more petitions are coming and adding all those issues, and if something is leaving outside, we would certainly be then chipping in, filing a substantial petition, not becoming party by way of impleadment. But yes, there are issues which have to be brought in before the court, that in these circumstances, these orders were passed, and what all has been brought before you, and what all had to be looked into.
Okay, so you're going to look
I
at that?
am of the
Right.
firm belief that there are so many things, in all fairness, for the judges also, things have to be brought before them.
Okay, so you, in all probabilities, Bilkis might make a legal move before that?
In all probability,
Yes. Okay. I appreciate both of you for joining us. Mr. Malhotra, I know you wanted to come in for a rebuttal, but thank you for taking out the time and joining us and expressing your concern and your views. All right, viewers, joining me right now is Nafisa Ali. Every day we have been trying to get voices in support of Bilkis Bano, because viewers, when the silence is louder than the voices that speak for her, it's important to keep getting people day in and day out. I have Nafisa Ali with me. Nafisa Ali, I'll just ask you one question. That one message that you'd want to give out the people of the country who are possibly still sitting on the fence when one needs to speak for Bilkis Bano. We banded together during Nirbhaya's time in 2012. What's stopping us now?
You know, in our country, if you beat a dog, the dog finally remains quiet. How much trauma, hurt, oppression are we all going to undergo before we unite as one force, which is a better, safer, secure, an India that the world looks up to at all times? When are we going to allow that to happen? We are now degrading our own value system. It must not happen, and people must speak out. And the Supreme Court of India, the only I would say the last bastion of doing right, must do right for this girl, Bilkis Bano, not because she is a Muslim, but because what happened to her and her unborn child and her family and her and those around her must not happen to anybody. My God, I will scream on top of every tower to stop atrocities, stop hate, stop the politics of hate. This is the politics of hate that makes you insane to do what these guys did. And all those people who are in the case that have let her go, they should also be held accountable by the court. They should also go to jail for misleading the court or doing injustice to the justice system. Justice is for all.
Nafisa Ali, actor and TMC leader, appreciate you joining us and voicing your concern and standing up importantly for Bilkis Bano. We urge everyone out there, the viewers, to put their ideology, their politics completely aside and think of what is the right thing to do.